Start so that we are not late for the cocktails. So good evening and welcome back to this last, but we keep it last because that also allows people to stay back through the day. And I think at least for this session, I have the easiest task to do. Introduce the debaters who need no introduction. So that's very easy. So we have a debate and we'll be moving a motion to this house about what we have discussed through the whole day and summarize where we stand as far as the theme of the arbitration conference today is, which is whether we are blazing new trails or taking 2 steps back. I think we'll, take a look at every other aspect, what has happened since the introduction of 1996 Act through the decisions of Bhatia International Venture Global, through BALCO 2015 Amendment Act, the positives around it, the 2019 Act, the things which we still have to achieve, and everything around it. So we have a stellar panel today for this debate. We have Darius, Khambata, and Ravi Kadam, senior advocates, Bombay High Court. Again, needs no introduction. We also have Michael Brindle and Salim Moollan, Queen's Counsel practicing in every part of the world, but based in London and Singapore, as we know. And the motion that we are moving to this house is that the House believes that the recent amendments to the Arbitration Act are necessary and appropriate to reform international arbitration in India. Over to Nish to introduce and moderate this debate. Thank you.
Thank you, Vyapak. Good evening, ladies and gentlemen. So, proposing the motion will be Salim and Ravi, and opposing the motion would be Michael and Darius. So, shall we hand over to Salim to begin?
Thank you, Nish. Thanks, Vyapak. Distinguished delegates, ladies and gentlemen, Ravi and I stand to support the motion. But first, it's important to understand what exactly the motion is. It was originally framed in line with the title of today's conference, i.e., is India blazing new trails in the field of international arbitration, or has it taken 2 steps back? It has since been reframed, as you can see, as the House believes that the recent amendments to the Arbitration Act are necessary and appropriate to reform international arbitration in India. These 2 motions are similar, of course, but not identical. And we think that matters not for pedantic reasons, but for substantive ones. For what we believe one should focus on, and what we intend to defend, is India's cumulative path over the past 10 years or so in the field of arbitration. The latest tweaks which have been brought in, or perhaps even more importantly, not brought in by way of the sections of the 2019 amendments which were notified on the 30th of August, are an important part of that story and one which we must discuss, but they are not the whole story, far from it. In terms of allocation of roles, I will be addressing the motion from the point of view of international practice and perception, and Ravi will be addressing it from the point of view of domestic Indian practice and perception. We emphasize this second aspect, perception, because if it is to succeed in establishing itself as a safe and reliable seat, India must not only make the changes necessary to actually create the conditions to become such a seat, it must do so in a way which is clearly perceptible to the outside world. So to answer our motion, let us begin to consider how India was perceived on the international arbitration scene, let's say a decade ago. I will just mention two issues. First, doubts continued to fester internationally and domestically as to the Indian court's approach to the annulment or non-recognition of awards on the grounds of purported non-compliance with Indian public policy in the wake of the saw pipe judgment. Secondly, India's approach to the annulment of foreign arbitral awards, i.e. the purported annulment under the Indian Arbitration and Conciliation Act 1996 of arbitral awards rendered in arbitration seated outside India, was, to put it neutrally, not considered to be in line with best practice. Focusing on the second of those issues, the extent to which this idiosyncrasy of Indian law jarred with international perception can perhaps best be seen from the investors' claims in White Industries against India, in which I should make clear, in the interest of full disclosure, I acted for the Republic of India. For in White Industries, the investor did not simply claim that it had been denied justice because of the delay taken by the Supreme Court to hear its case, a claim that was dismissed by the arbitral tribunal, or that that delay had breached an effective means clause which should be held to have been imported into the relevant BIT by means of the BIT's MFN clause, a claim that was upheld by the tribunal. It went much further. It contended that the very regime for the challenge and recognition of foreign awards which existed in India was in breach of the New York Convention, and thus, through legal reasoning, which I confess never had to have fully understood, also in breach of the BIT. The claim can certainly be seen as somewhat creative, and it was dismissed by the arbitral tribunal, although not by the arbitrator appointed by the claimants. I'm sure that was just a coincidence. But in terms of perception, it should, we submit, remind all of us of where India was not so long ago, in 2011, and how it was being perceived. Now, the Indian Supreme Court heard the international and domestic criticism regarding this regime for the challenge of arbitral awards, and it acted to set the matter right. I'm talking, of course, of the Balco judgment. Now, such positive judicial interventionism is not, we humbly submit, the sign of a jurisdiction that is taking two steps back. Over the past few years, that judicial interventionism has been coupled with private sector and legislative efforts to create the conditions for arbitration to thrive in India. I can be brief about the private sector initiatives. The drive to institutionalize arbitration in India and the successful development of the institution which is hosting us today, the Mcia, is further evidence of a jurisdiction that is, we humbly submit, not taking two steps back. As for legislative interventions, let me begin by stating what is perhaps obvious, but not very often articulated in debates such as this one. Not many jurisdictions actually take the time to articulate potential legislative reforms in the field of arbitration, whether through high-level committees or otherwise, let alone take the time to put them into actual legislation. That India, a country with over 1 billion inhabitants with a fair few legislative priorities, has been actively doing so for the past 5 years is, we humbly submit, not the sign of a jurisdiction that is taking two steps back. Now, one can certainly debate the extent to which those attempts by the legislature to assist the establishment of India as a safe seat for arbitration have been or will be successful, but that assessment cannot be disconnected from the efforts which I have just highlighted. They cannot be judged in a vacuum. They must be judged against the background of where India was prior to their introduction, and they must also be judged bearing in mind that first impressions can often be deceptive. Let us now do that. Let us start with the 2015 amendments. My task in that respect has been made considerably easier by Mrs. Justice Malhotra's lucid exposition of the amendments this morning. Let me remind you briefly of the main changes introduced by the legislation. changes to the Section 11 powers of appointment to try and deter the abuse thereof by recalcitrant parties and render them efficient, changes to the rules on conflicts of interest to bring in best international practices and get rid of certain noted abuses by parties with dominant bargaining positions, changes to the rules on the grant of interim relief by tribunals to give wider powers to tribunals, an attempt to stop courts from reviewing awards on the merits under the guise of public policy, and provisions to stop the abuse of automatic stays following on from the challenge of arbitral awards. Now, none of these are the signs of a jurisdiction that is taking 2 steps back. The one aspect which drew criticism at the time in 2015 was the setting of absolute timelines for the rendering of awards. Again, that is not prima facie the sign of a backward-looking jurisdiction. Quite the opposite. It is the sign of a jurisdiction that is looking to create the right conditions for arbitration to develop efficiently. But it was said at the time that these timelines imposed were too short and too drastic. Speaking to colleagues in India 4 years on, the consensus appears to be that the provisions have in fact not proved problematic in practice. Indeed, we've just had a panel debating whether the changes made to these provisions, I quote, whether the reversal of the strict timelines in the amended act sets India back. So the perception of 2015 seems to have gone full circle. As I have said, one should be cautious about passing final judgment based on first impressions. And so to the 2019 amendments. Again, I can take this briefly, thanks to Mrs. Justice Malhotra's detailed explanations this morning. The new law contains a number of uncontroversial provisions. All of them are, once again, clearly designed to foster arbitration, not undermine it. The confidentiality of commercial arbitration is given statutory recognition and becomes enforceable before the courts. Arbitrators are granted express statutory immunity. Challenges to awards under the equivalent of Article 34(1)(a) of the model law are made expressly subject to a limitation that the relevant evidence must have been on the record in the arbitration, and it is clarified that the only avenue to challenge an arbitral award is that under the Arbitration Act. None of these are the signs of a jurisdiction that is taking 2 steps back. But 2 sets of provisions are attracting immediate criticism, or should I say first impression criticism. First, the creation of the proposed Arbitration Council of India, which it is said is being given the statutory teeth of a regulator. And secondly, the changes to the appointment procedures under Section 11 of the Act, which would themselves be linked to this new council. Ravi may address you more in detail on the substance of these provisions, but our main answer to this point is fairly straightforward. These provisions have not been notified and do not have the force of law. Now, this is clearly no accident, and it shows, we respectfully submit, that the powers that be are clearly listening to the voices coming from the arbitration community. This, again, is not the sign of a jurisdiction that is about to take 2 steps back. And the answer to the current wrinkle is to engage with the legislator and bring about the drafting changes which will ensure that these provisions, which are clearly meant by the legislator to effect arbitration-friendly changes, in fact achieve their intended purpose. That purpose, the institutionalization of arbitration in India, is a laudable one, and one which only this afternoon our colleagues at the Mcia were describing to me as the most important struggle of those who are looking to establish India as a safe seat for arbitration. Now,
just as a time check, Salim, it's 11 minutes.
Thank you. It is a striking feature of the current Indian arbitration scene that struggle is one which is being fought by government together with and alongside the private sector. Following their non-notification, there is now time to even out the aspects which are being criticized in the provisions which are yet to be notified. Mrs. Justice Malhotra tells us that it is not the intention of the legislator that the new Arbitration Council of India should be a regulator. It is meant to be, to coin a phrase, a facilitator of institutionalization. I think all of us on this panel agree that the words used in the current unnotified provisions do not achieve that purpose. The feelings of the arbitral community should be fed back to the legislator and the legislation amended to achieve its intended purpose prior to it being notified. Again, Mrs. Justice Malhotra, after the panel, spoke to some of us, including Nish here, to explain that it was not the intention of the legislator for Schedule 8 to bar international practitioners from arbitrating in Indian-seated arbitrations. Now, if that is the case, and we have no reason to doubt that, then we would humbly submit that the provisions could have been more felicitously drafted. Again, that can and should be fixed before the relevant sections are notified. These two instances of provisions which are yet to become law do not constitute two steps back, and we should all take great care not to exaggerate their significance, but rather to engage with the powers that be to ensure that they do not slow down the substantial efforts which all involved in arbitration in India have put into creating the conditions for India to develop as a safe and efficient seat for arbitration in years to come. I thank you for your attention and now give the floor to Ravi for a few minutes, but I will leave the entire reply to him, Nish.
Thank you, Salim.
That's Salim and I, of course, we are for the proposition that the recent amendments, and when we say recent amendments, we include the 2015 amendments, are necessary and appropriate for reforming arbitration in India. We also believe that if you look at the position since it's 1996 to 2010 or 12 as one time, and 2012 onwards, in the last 6-7 years as another time, that further you divide BALCO as a kind of watershed and take the period after BALCO and see that the legislature did really nothing between 1996 and 2015, actually almost 2016 because it's Act 3 of 2016, the 2015 amendment. After 20 years, in the next 4 years, it's made two sets of amendments. Therefore, the legislature now has woken up and is keeping step with what otherwise exclusively the judiciary was doing. So the role of reform was with courts. That role is now where it ought to be. It's being discharged by the legislature. Now, I know there is and in the course of this debate, a great degree of concern over the provisions of the 2019 amendment, especially those relating to the Arbitration Council, etc. Firstly, they have not yet been notified, an appointed date has not been given for those provisions. But even as and when it happens, what I would like to emphasize is that if you read the scheme of the 2019 Amending Act, and maybe today, maybe some other day, you will see that the whole scheme of the 2019 Amending Act is really to strengthen institutional arbitration and a concerted effort on the part of the legislature by giving a mechanism to strengthen institutional arbitration as opposed to ad hoc arbitration. The provisions of the Amending Act, as and when those which are not notified come in, I feel will be tempered by the regulations which are contemplated in the Amending Act. If you see, there is a power in 43L to make regulations. And many of the important sections, 43H, 43I, say that the powers under 43H and 43I will be exercised in accordance with the regulations that will be made. So there is still a regulatory regime in which you will get how these powers are to be exercised and how the grading of arbitral institutions, etc., will come in. There is cause for concern, of course, on the Arbitration Council, but I feel even that, as you learned this morning, has not yet been notified. Possibly there is a rethink, either to reformulate it and put it in a different way so as to have more independence there, or to drop it altogether. What my emphasis is going to be, and I have very few minutes today, is that we have traveled a long way. And if you see the changes in the context of where we were to where we are, then definitely the amendments made in the law in 2015 and in 2019. I could deal with each one of them. Maybe I will do it in my turn later. But just broadly, if you look at it, the whole ambit of 34 had been virtually taken to one extreme by judicial interpretation, which the legislation of 2015 brought it back on even keel. And thankfully, subsequent judgments, including Justice Nariman's recent judgment in Song Yang's case, have brought that back and kept it within a narrow confine as it ought to be, so that the freedom to have proper decision-making through an arbitral forum without civil courts interfering excessively is brought back. Equally, I feel the single most, according to me, important change in the law in the two amendments of 2015, really in 2015 and now, is the imposition of timelines. For everything, timelines, and particularly 29A, where the timeline of 12 months is given to the arbitrators, which is now amended. 12 months will commence from the date on which the pleadings are completed and for which 6 months are given. You will notice in legislation, at least I have noticed as a lawyer in legislation in the last 3, 4, 5 years, there is a conscious awareness on the part of the legislature and on all of our parts also, that the biggest impediment to justice is the slow process, the slow justice that we get, whether it's in courts or in arbitration. So you find that legislations, whether it is this law, whether the Insolvency Act, whether the Commercial Courts Act, all these laws, and particularly the Arbitration Act in so many different provisions, have given timelines, advisedly not given the same timelines for international arbitrations, thinking obviously that they will do it anyway within a reasonable period. But the whole trend is that the legislations which have come by way of amendments are definitely taking the cause of commercial arbitration forward. I'd rather answer when my turn comes, since we, as a team, we have a time limit. But for the moment, I think this is it. Thank you.
Thank you, Ravi. Michael?
I'm going to speak from the point of view of an international arbitration practitioner, an arbitrator. From that point of view, the 2015 amendments, pretty obviously, were, on the whole, consistent with the advancement of arbitration in India. I'm not going to spend much time on them. I note that our opponents in this debate are very keen, when they're looking at recent amendments, to concentrate on the earlier amendments, 2015 amendments, and not on the 2019 amendments. And I think we all know that what this debate is really about is the 2019 amendments. But what a funny mixed bag they are. I was struck by what Justice Patel said at yesterday's dinner. What a miscellany they are, a mixture of bits and pieces. And it's very hard to take an overall view. He, in that speech, said that there is the need, and I was struck by this, to always differentiate between international arbitration and domestic arbitration. He goes so far as to say they should be in separate acts. I'm not sure they need to be in separate acts, but one does have to be sure, when amending the law, whether it's being done in the context of purely domestic or of international arbitration, where very different considerations can come into play. Now, cutting to the chase, the 2019 amendments have two major horror problems in them. One of them I'm going to say very little about, and one slightly more. The one I'm going to say very little about is Schedule 8. I'm going to say very little about that for three reasons. Firstly, you don't want to hear me advertising myself as being an ideal person to sit in an Indian-seated arbitration. So I won't bore you with that. Secondly, I can't possibly tell you what Schedule 8 means. I'm not an Indian lawyer, and I have no idea what the legal effect of it is in India. Thirdly, there is reason to doubt, I put it no higher than that, from discussions with my colleagues, that the intention was to exclude foreign lawyers from Indian-based arbitrations of an international kind. And so I will leave it at that. I'm going to come on to the other horror story, which is the Arbitration Council of India. I heard this morning that this was initially going to say something about promoting arbitration, but that word has been removed. And what it now looks like is a ghastly, bureaucratic, government-controlled nightmare, which is capable of undoing a lot of the good work, which undoubtedly is being done elsewhere, to advance international arbitration in India. Now, of course, the point of all this was the high-level committee, or the high-profile committee, that was set up to look into institutionalization. And yes, of course, it's absolutely true, there's a desperate need for institutions in India, arbitration institutions. That's what the MCIA is all about. And I think I haven't met a single person who wouldn't agree with the importance of institutions to deal with international arbitration in India. But there's a terrible confusion, it seems to me, or danger of confusion, between the need to have institutions, which is good, and the need to have oversight of institutions, which is what this council seems to be. There are three problems with the council, I think. One is that it's going to be controlled by the government to a very large extent. I think there thought to be probably 7 members, of whom 5 would be government appointed. So that's most unfortunate. The legislation has advanced beyond what the committee recommended, because the committee said there should at least be a foreign practitioner on the council, but that's been dropped. So it just looks like heavy-handed bureaucracy now. And international parties are going to run a mile. Can you see somebody wanting, a foreign party, a German company or something, wanting to put in an arbitration clause in its contract to litigate, to arbitrate in India, if it knows that the process is overseen by a government-backed advisory quango? They'll run a mile. The second problem is the powers of this body. The committee said it shouldn't be a regulator. But as a gentleman, I think Mr. Mukherjee this morning was telling us, the section is replete with references to regulation. Plainly, this advisory body, this council, will have regulatory powers. Thirdly, there's a question of accreditation. I'm not going to deal with that at length because I haven't time, and I think Darius will deal with that. I wouldn't have thought accreditation is needed at all, but if it is, it certainly should be a process which is government-controlled. I noted that this morning, the gentleman who was in favour of it, Mr. Thukral, I think, was really seen to be talking almost entirely about domestic arbitrations. That seemed to be his main concern, and in that context, I've got not much more to say. So, my time is moving on. I think this could prove to be a disaster. Now, my opponent's answer to that is, oh, don't worry about it, because it's not been notified, and nor has the Schedule 8 been notified. But the fact that it's not been notified, as I understand it, doesn't mean it isn't going to come into force. It just means it hasn't yet come into force, and we don't know why. And it might come into force at any time. But the motion concerns recent amendments. And it seems to me that on 2 bases, in particular the question of the Arbitration Council, there is major reason to think that the recent amendments have not been conducive to what the government says, and I believe them, I'm sure, they're trying to do, namely to promote international arbitration. Now, my time may be out, but I'll just, if I have 1 more minute, do I have 1 more minute? I would just like to do with one other point, which is the question of confidentiality. Now, this was dealt with, I think, quite clearly this morning by the various speakers, but you will see that there has now been recognition that the arbitral process is confidential. The difficulty with it is that there's a very narrow exception. The only exception is for the purposes of implementation and enforcement of an award. And as I think other speakers said earlier today, there are many other situations where one would have thought there would have to be an exception to the requirement of confidentiality. I won't list them now, I haven't time, which are not catered for in the legislation. Now, this is, I think, an example of why it was a bad idea to put this in the statute. In England, although we've had this very comprehensive Arbitration Act 1996 for a long time, it says nothing about confidentiality at all. And this is something that the common law has worked out, just as it did with banking confidentiality, with the Tournier case exceptions to banking confidentiality. So the courts in England have worked out sensibly exceptions as they've needed to be worked out to the overall confidentiality regime. So unfortunately, this matter is rather unsatisfactory at the moment, and I think it would have been better not to have legislated for that at all. Thank you very much.
Thank you, Michael. Darius?
It's always an advantage coming in fourth because the issue is considerably narrowed since this debate started. I think Salim and Ravi have as much as conceded that without the benefit of the pro-arbitration movement in India from 2012 onwards, these amendments would be a major problem. I think everyone knows what these amendments are. They are the 2019 amendments, because I don't believe that blazing new trails takes us back to 2012. We have to look forward. I mean, how far back can you go? White Industries was 10 years ago. We are blazing new trails, or are we taking 2 steps backward? And that can be only a reference to the 2019 amendments. Cutting to the chase, it's very clear that the 19 amendments score 6 own goals and mark 3 lost opportunities. The 6 own goals, very briefly, are the Arbitration Council of India, the sort of super regulator, masked in very vague and general language, the big brother that is going to overlook arbitration in India in the future. Michael has dealt with that. The second is the accreditation of arbitrators and their qualifications. I'm going to deal with that in little detail shortly. But that really is a retrograde move. It will reduce the pool of available arbitrators for international commercial arbitration particularly. The third are the amendments to Section 11, a positive amendment where an arbitral institution can be designated to appoint arbitrators, but 2 negative steps which I'll speak about. The fourth, of course, is confidentiality. Michael has spoken on that. The fifth is something that has sneaked into Section 45 almost by accident, and it does exactly the opposite of what the Shri Krishna Committee recommended. And the sixth is the unfortunate Section 87, which now takes away the benefit of the 2015 amendments. The very amendments my learned friends thought were great, and they are, but it takes away the benefit of those very amendments from arbitral proceedings that have commenced prior to 23rd October 2015, or in relation to court proceedings, even if they've commenced after 23rd October 2015, but if they are in relation to arbitral proceedings prior thereto. So these are the 6 own goals. And straight away to Section 43J and the 8th schedule. Now, all of you know that, and any student of arbitration knows that party autonomy is one of the columns of arbitration. Now, this provision rides a coach and four through party autonomy. There's this wonderful statement in a US 7th Circuit decision which says party autonomy is the freedom of parties to stipulate the dispute resolution procedure, which can be near absolute, short of trial by ordeal or battle, or more doubtfully, by a panel of 3 monkeys. Now, that party autonomy has been whittled down to a list of the only people who can be appointed arbitrators. And of course, and congratulations to all of us in this room, the first on that list is lawyers qualified under the Indian Advocates Act, who've had practiced for at least 10 years. And following this are engineers, cost accountants, chartered accountants, all qualified in India, all with a 10-year barrier. Now, no arbitration rules or statutes across the world have this sort of restriction. And I should have thought that by now, Indian arbitrators and Indian lawyers have far more talent and confidence than the 8th schedule grants to them. I think we can hold our own with anybody, and there's no reason to restrict the pool, the choice that individuals have when they arbitrate in India to only Indians. I think this is a retrograde move, and thankfully not yet notified, but still part of the amendments that we are debating today. What's even more hair-raising are the general norms that have been put in to the 8th schedule. And when you read them, they're almost impossible. They require an arbitrator to have a good working knowledge of the Constitution of India, of commercial law, of labor laws. I don't think most of us in this room have that sort of knowledge, let alone cost accountants, chartered accountants, and engineers. So I'm not sure how the draftsman expects anyone in the list that he has prescribed from items 1 to 9 to have that sort of knowledge. And he speaks of having necessary to have robust understanding of commercial practice and case management. I'm not sure what he meant by that. But all of it seems like an unnecessary imposition on party autonomy. And nothing in it will encourage institutionalized arbitration, which I thought was the basic motive moving these amendments. The second area is Section 11. Section 11, one good move there. The Chief Justice of the Supreme Court or the High Court can designate arbitral institutions to appoint arbitrators. But wait a minute. If there are no designated institutions, then that Chief Justice has to look to the panel of arbitrators of that High Court, individuals. And that panel, the individual on the panel, is to act as the arbitration institution. I mean, the mind boggles. You're going to have arbitrators appointing arbitrators. That's again unnecessary. Then you've got the deletion of 11.6a. 11.6a is the provision that the 2015 amendments, the great amendments brought in, which laid to rest the ghost of Patel engineering, which is to say, at the stage you're appointing an arbitrator, the only thing that the appointing authority can do is to decide the existence of the agreement, nothing more. It must then go to arbitration. That has been deleted. And that raises an ambivalence. What is the designated institution to do if there are objections to arbitration at the stage at which it has to appoint arbitrators? I can see Nish looking at me. I'm not sure how much time I've got left. But
15 minutes have passed in total between the two of you.
Okay, so then that's the call to stop. I'll just end very briefly with the 3 lost opportunities. 29A, there could have easily been an amendment to say it doesn't apply to institutionalized arbitrations, which is to say whether domestic or foreign. This feeling of discrimination against domestic arbitrations would have gone, and it would have kick-started institutional arbitration in India. Niti would have been very happy for that. 2, it gives up the chance to enforce emergency awards made by institutions abroad. And 3, there is no attempt at regulating third-party funding, which is really a vacuum in our law with this thing. Thank you.
Thank you, Darius. In terms of a reply, Ravi?
People forget, and my colleagues also, both despite being lawyers, what we forget is that the legislature of each country is presumed to be aware and alive to the needs and requirements of each country. So what you may find is something that maybe in another jurisdiction you may not like it. It may be something that, given the state of your country, the state of development of arbitral institutions in your country, it may be necessary. And eventually, maybe at some point in time when this entire ecosystem is well developed and progressed and sufficiently on par, which probably the legislature believes it's not, then maybe there may be changes. Because all legislation, we remember, is trial and error. It is part of a process. So without knowing, because when the legislature or parliament in India legislates, it doesn't legislate, and you must remember this, it doesn't legislate for Bombay or it does, and arbitrations which take place here. It doesn't legislate only for Delhi, but it legislates for the whole length and breadth of country, for Pune, Kolhapur, Satara, wherever there will be arbitrations. So the purpose and object of prescribing that you must go through arbitral institutions, that for being accredited as an arbitrator for those institutions, certain norms must be there. They may be, I can concede, there may be somewhere some specific norms which may be difficult to have. As I can see, if you have there's a prescription of a norm for an arbitrator who should know both domestic and international commercial laws, which may not be necessary. So it's probably at some stage when they come with it. Therefore, I began by saying that when the regulations come and the whole regime is put in place, you will know that the provisions of the 2090 Amending Act are salutary. They will take the arbitration institutions forward. To call it bureaucratic, because initially the structure is that, as it stands today, the structure is that most of the nominees are government nominated. But that doesn't mean, even in many places where they are government nominated, but the requirement of the statute is that he should be a judge or a Supreme Court judge or a retired Chief Justice. Therefore, I would believe that the provisions are sufficient. There are sufficient inbuilt safeguards in the law so as to take care of any fear that it will, undue fear rather, that it will be excessively bureaucratic. The need to have institutions cannot be denied. It is conceded by both. The provisions which make or which are prescribing different requirements are not in the nature of an oversight or control, but they are regulations to guide the persons who take decisions in the council. In the absence of regulations being put, you will say that these are untrammeled powers and therefore they are too wide and therefore required to be struck down. Therefore, regulations are put in to guide the decision makers so that they take decisions. That's normal in any legislation, and this is legislative drafting, which requires, because you'll then say that no, it is too wide, it is uncanalized, it is arbitrary, and therefore strike down the provision. Therefore, you must understand that this entire scheme is a holistic scheme, which is necessary. Coming to what my friend Darius said, I would just deal with his contention, really, that so far as the recommendations of the Sri Krishna Committee, many of the provisions are in the teeth of their recommendations, which is a fact. But he also seems to feel that the regulatory, or rather the framework of the council and its powers are such that it will be a big brother or a super regulator. As I explained, that's not the intention. And if you read them very carefully and read them in the context in which they are there, and read them in an all-India context, where in many places there is necessity to have a guidance as to who can be an arbitrator and who cannot be. I can understand that you need not exclude anyone, but it is necessary when you initially lay down norms to prescribe specifically who can come in, and not just any layperson who has no knowledge of the subject. And therefore, each one of those provisions, I don't think, and I don't read these regulations where you say that these are the norms to be an arbitrator, that each arbitrator must have all those conditions. It's impossible for one person to have, if he's an engineer, you don't expect him to know the Constitution of India. So therefore, you have to read them in the context in which the requirement will be, and that is how eventually courts will interpret them. Therefore, in my view, this is a salutary legislation. We always, just remember, we all had great doubts about the efficacy of having 29A. Today you feel that 29A has worked and the time limits imposed there are working, and a large number of arbitrations are getting over quickly. And at that time you said, no, the autonomy of arbitrators, you are imposing time limits on them, you'll get hasty, haphazard awards. That has not happened. So let's allow these legislation to go through. Some of the provisions will undergo change between now and by the time they come with the regulatory framework coming in. But in my view, these are salutary laws. The 2019 amendment is a good amendment. It is taking us in the right direction. We must remember that we are different from other countries. And therefore, these laws are required here. Thank you.
Thank you, Ravi. Further response?
I think Ravi Kadam's very subtle and interesting reply rather gives the game away. He seeks to interpret the new legislation in a way which may be right, possibly, but it's certainly not obviously right, and it couldn't be proved to be right without a great deal of litigation, possibly taking 10 years up to the Supreme Court. He says there's no intention to make a super regulator out of this council. But just read the statute. What does it say? That's the problem with his position. And it's the same with the point about foreign lawyers being able to serve. He says, well, you can interpret Schedule 8 to mean this, that, and the other, but you could interpret it the other way as well. The question is, what does it say? What are these amendments? Are they or are they not conducive to international arbitration in India? That's my first point. My second and last point is to return to my example. And let us imagine a German company thinking of entering into a contract with an Indian company. And the concept of having arbitration of disputes in India is being considered as to whether there's perhaps there's an Mcia clause going to be put in to the contract. And the German company gets advice from an Indian law firm as to the effect of litigating or arbitrating, I'm sorry, not litigating, arbitrating in India. And he's told two things. He's told, firstly, that there is a thing called the Arbitration Council, which, as I would put it, is a heavy-handed government-based regulator over the whole process. And he's also told that he may well have to, although it's not certain, but it's possible, that he may not be able to have any arbitrator on the panel other than an Indian. What is that German company going to do? There is only one possible answer. He's going to run a mile. And so will they all. How can this possibly be conducive to the government's own stated aim of encouraging, promoting international companies to come and arbitrate in India? Thank you.
Thank you, Michael. Actually, you've given us a great closing. I think there's much agreement in this debate. All of us agree that there was a lot of positivity in the way the law of arbitration was going in India, at least up to 2015. And all of us agree that it's important to engage with the government to make sure we don't take the wrong route this time. But these amendments remind me of the title to a book written by Field Marshal Manstein called Lost Victories. We were marching forward positively, but these amendments, I think, are going to derail those victories that we won with a lot of struggle in the years up to 2015. No doubt legislation is trial and error, but there must be some certainty about it as well. You set up an expert committee, you're expected to follow its recommendations. These amendments don't always follow the committee's recommendations. With more time, I could explain to you how Section 45 is really another horror story, because they've actually achieved the opposite result to what the committee wanted, though purporting to reach the same result, by cancelling the word not from the committee's recommendation. The committee had a double negative. The amendments leave out the word not, I don't know why, and they've achieved exactly the opposite result. So there needs to be a lot of cleaning up in these amendments, and very quickly. Let's not be apologetic. It is a process of trial and error, and that's why you have forums like this and debates like these to voice positive criticism. It's not negative to criticize, it's positive. And if we want to blaze these new trails, we want to blaze new and positive trails forward. And I think we can do that by unequivocally rejecting this motion and saying that we don't believe that these recent amendments are necessary and appropriate to reform international arbitration in India. I have no doubt that this House will do so, and I have confidence that that will be an aid and will assist the cause of arbitration in India. Thank you.
Thank you, Darius. Ladies and gentlemen, as advocates, it's always really hard to put forward a position that's been imposed upon us, regardless of whether we believe in the position or not. What I think we've all benefited from this evening is advocacy at its highest, and we all should thank the debaters for that privilege. Now, every debate has to have a conclusion, and for that, I'm going to turn over to all of you as judges and ask you through applause to indicate which team won. So let me start with those for the motion. If you think that those for the motion won, then please clap now. Okay, and for those opposing the motion, please clap now. Sounds like a tie to me. On that note, join me in thanking them again, and we bring the final session to a close.